Good morning all. Today we are going to discuss about the partnership form of business. So first we can discuss about the definitions of partnership. According to the Indian Contract Act 1872, partnership is the relation which subsists between persons who have agreed to combine their property, labor or skill in some business and to share the profits therefrom between them. So the partnership is the relationship between the persons who have agreed to share or combine their property, labor, or skill in a particular business and to share the profits among them. According to the Indian Partnership Act 1932, the partnership is defined as the relation between persons who have agreed to share the profit of the business carried on by all or any one of them acting for all. The next is the features of partnership form of business. The first one is about the formation. The partnership form of business organization is governed by the Indian Partnership Act 1932. It comes into existence through a legal agreement wherein terms and conditions governing the relationship among the partners, sharing of profits and losses, and the manner of conducting the business are specified. It may be pointed out that the business must be lawful and run with the motive of profit. Thus, two people coming together for charitable purposes will not constitute a partnership. So, there must be a profit motive to carry out the business. About the liability. The partners of a firm have unlimited liability. Personal assets may be used for repaying debts in case the business assets are insufficient. Further, the partners are jointly and individually liable for payment of debts. The next is the risk bearing. The partners bear the risk involved in running a business as a team. The reward comes in the form of profits which are shared by the partners in an agreed ratio. However, they also share losses in the same ratio in the event of the firm incurring losses. So, the profits and losses of the firm will be shared in the same ratio among the partners. The next is decision making and control. The partners share amongst themselves the responsibility of decision making and control of day-to-day activities. Decisions are generally taken with mutual consents. Thus, the activities of a partnership firm are managed through the joint efforts of all the partners. Continuity. A partnership is characterized by lack of continuity of business since the death, retirement, insolvency or insanity of any partner can bring an end to the business. However, the remaining partners may, if they so desire, continue the business on the basis of a new agreement. So, if any partner is dead or retired or become insolvent, the partnership agreement will come to an end, and the remaining partners, if they want to continue the operation, they want to reconstitute a new agreement. The next is number of partners. The minimum number of partners needed to start a partnership firm is 2. According to section 464 of the Companies Act 2013, maximum number of partners in a partnership firm can be 100, subject to the number prescribed by the government. As per rule 10 of the Companies Rules 2014, at present the maximum number of members can be 50. So, the number of partners in a partnership firm can be a minimum of 2 and a maximum of 50. Next one is the mutual agency. The definition of partnership highlights the fact that it is a business carried on by all or any one of the partners acting for all. In other words, every partner is both an agent and a principal. He is an agent of other partners as he represents them and thereby binds them through his acts. He is a principal as he too can be bound by the acts of other partners. The next topic is the merits of partnership firms. First one, ease of formation and closure. A partnership firm can be formed easily by putting an agreement between the prospective partners into place whereby they agree to carry out the business of the firm and share risk. There is no compulsion with respect to registration of the firm. Closure of the firm too is an easy task. Balanced decision making. The partners can oversee different functions according to their areas of expertise because an individual is not forced to handle different activities. This not only reduces the burden of work but also leads to fewer errors in judgments. As a consequence, decisions are literally to be more balanced. Next one, more funds. In a partnership, the capital is contributed by a number of partners. This makes it possible to raise larger amount of funds as compared to a sole proprietor and undertake additional operations when needed. Sharing of risk. The risk involved in running a partnership firm are shared by all the partners. This reduces the anxiety, burden, and stress on individual partners. Secrecy. A partnership firm is not legally required to publish its account and submit its reports. Hence, it is able to maintain confidentiality of information relating to its operations. The next is the limitations of partnership firm. First one, unlimited liability. Partners are liable to repay debts even from their personal resources in case the business assets are not sufficient to meet its debts. The liability of partners is both joint and several, which may prove to be a drawback for those partners who have greater personal wealth. They will have to repay the entire debt in case the other partners are unable to do so. Limited resources. There is a restriction on the number of partners, and hence, contribution in terms of capital investment is usually not sufficient to support large scale business operations. As a result, partnership firms face problems in expansion beyond a certain size. Possibility of conflicts. Partnership is run by a group of persons wherein decision making authority is shared. Difference in opinion on some issues may lead to disputes between partners. Further, decisions of one partner are binding on other partners. Thus, an unwise decision by someone may result in financial ruin for all others. In case a partner decides to leave the firm, this can result in termination of partnership as there is a restriction on transfer of ownership. Lack of continuity. Partnership comes to an end with the death, retirement, insolvency, or lunacy of any partner. It may result in lack of continuity. However, the remaining partners can enter into a fresh agreement and continue to run the business. Lack of public confidence. A partnership firm is not legally required to publish its financial reports or make other related information public. It is therefore difficult for any member of the public to ascertain the true financial status of a partnership firm. Types of partners. A partnership firm can have different types of partners with different roles and liabilities. An understanding of these types is important for a clear understanding of their rights and responsibilities. So, the first one is active partner. An active partner is one who contributes capital, participates in the management of the firm, shares its profits and losses, and is liable to an unlimited extent to the creditors of the firm. These partners take actual part in carrying out business of the firm on behalf of other partners. Next is sleeping or dormant partner. Partners who do not take part in the day-to-day activities of the business are called sleeping partners. A sleeping partner, however, contributes capital to the firm, shares its profits and losses, and has unlimited liability. So there is only one difference in active partner and sleeping partner. Active partner participates in the management of day-to-day activities, but the sleeping partner do not take part in the day-to-day activities of the business. Next one is secret partner. A secret partner is one whose association with the firm is unknown to the general public. Other than this distinct feature, in all other aspects, he is like the rest of the partners. He contributes to the capital of the firm, takes part in the management, shares its profits and losses, and has unlimited liability towards the creditors. There is only one difference in secret partner and active partner. The partner is unknown to the general public. Next is nominal partner. A nominal partner is one who allows the use of his or her name by a firm but does not contribute to its capital. He or she does not take active part in managing the firm, does not share its profits or losses, but is liable, like other partners, to the third parties for the repayments of the firm's debts. Next is partner by estoppel. A person is considered a partner by estoppel if through his or her own initiative, conduct or behavior, he or she gives an impression to others that he or she is a partner of the firm. Such partners are held liable for the debts of the firm because in the eyes of the third party they are considered partners even though they do not contribute capital or take partner by holding out. A partner by holding out is a person who, though is not a partner in a firm, but knowingly allows himself or herself to be represented as a partner in a firm. Such a person becomes liable to outside creditors for repayment of any debts which have been extended to the firm on the basis of such representation. In case he is not really a partner and wants to save himself from such a liability, he should immediately issue a denial clarifying his position that he is not a partner in the firm. If he does not do so, he will be responsible to the third party for any such debts. So, we discussed about 6 types of partners. The first one is active partner, where he contributes the capital, participates in management, shares or profits or losses, and have unlimited liability. The next is sleeping partner. He is also contributes capital, shares profits or losses, and have unlimited liability but does not participate in management. For secret partner, he also contributes to the capital, participates in management, share profits or losses, and have unlimited liability, but it's secret to the general public. In nominal partner, he does not contribute capital, does not participate in management, generally does not share profits or losses, but have unlimited liability. In both the partner by estoppel and partner by holding out, they both does not contribute to capital, does not participate in management, does not share profits or losses, but have unlimited liability. Let's take a test based on what we learned today. Okay, I will give you some questions. Just think about it and answer the questions. The first question is: a partner whose association with the firm is unknown to the general public is called. You have 5 seconds to think and answer the question. It's the secret partner. Name the partner who does not participate in management but contribute capital. He is the sleeping partner or the dormant partner. Partnership form of business is governed by which rule? The Indian Partnership Act 1932. Which of the following is not the limitation of a partnership firm? Unlimited liability, lack of secrecy, limited resources, lack of continuity. Lack of secrecy is the right answer because the partnership firm constitutes with the secrecy. So, congratulations for all those who have answered correctly and thank you.